We're now going to sort of dive into the cross-cutting federal requirements. So Rebecca touched on these earlier, but what we know is when we are using federal funds for a procurement, that there are a variety of requirements from different sources that are going to apply. And those are going to apply whether we're using CDBG-DR, EPA, FEMA, right? Wherever these funds are coming from, we're going to have some cross-cutting requirements. So the way that we're going to approach this is we're going to sort of start with the uniform guidance, right? I always want to start there because I think that's the most basic building block of federal procurement and contracting. So we're going to start by looking at the required contract clauses that we find in the uniform guidance. And then we're going to get into CDBG specific requirements. So Section 3, Section 104D, and the URA. And then lastly, we're going to end by talking about conflicts of interest and other regulations on public employees' conduct. So that's our roadmap for part 2. We are going to start, like I said, with the contract clauses. So before we get into looking at all of the contract clauses that we find in the uniform guidance, I want to just remind you that your contract should be in writing, right? And so in some instances, we find that requirement explicitly in state law and the uniform guidance, right? So 160A-16, general statute, requires agreements for municipalities to be in writing. Construction and repair contracts in the formal range have to be in writing. If we're talking about the purchase of goods, the Uniform Commercial Code, which is codified in our general statutes, requires contracts to be in writing for any purchase over $500, right? So we have a lot of state law requirements that lead us to putting our contracts in writing. We also know that the uniform guidance says that our contracts must include clauses identified in the uniform guidance. Now, the uniform guidance doesn't say your contracts have to be in writing, but I think the implication here, right? If you're including the contract clauses, then you're going to have a writing where you're including those contract clauses, right? And I want to be sort of clear here about what I mean when I say contract. Contract is a really broad term. Writing is a pretty broad term too. And so, you know, when you think of contract, my guess is that you're thinking of sort of the long form contract that your attorneys are looking over, and it's got boilerplate and lots and lots and lots of clauses, lots of pages, and that is a contract for sure. But we also have other sort of legal vehicles that are contracts. A purchase order, for example, is a contract. Memorandum of understanding, a memorandum of agreement is a contract, right? And sometimes those are drafted to be non-binding, but certainly it is an agreement. And if it's legally binding, then it's a contract. All right, so we've got to have our contracts in writing. That's sort of the first point that I want to make here. The uniform guidance goes on to tell us that there are specific contract clauses that need to be included. So we find this in 2 different places in the uniform guidance, kind of one references the other. So the first place that we find it is 2 CFR 200.327, and it says the recipient or subrecipient's contracts must contain the applicable provisions described in Appendix 2. So then we have to hop on over to Appendix 2, and Appendix 2 says, in addition to other provisions required by the federal agency or non-federal entity, all contracts made by the non-federal entity under the federal award must contain provisions covering the following as applicable, ... So a couple of things I want to point out here about that Appendix 2 language. So what it says first is, in addition to other provisions required by the federal agency or non-federal entity, which would be the state in this case, all contracts made by the non-federal entity under the federal award must contain provisions covering the following as applicable. So that first portion that's highlighted, the significance of that is that the federal agency may require more than what we find here. And that is the case with CDBG-DR. So we're going to be talking now about the Uniform Guidance Contract Clauses, but then we'll be talking about CDBG's specific sort of contract requirements and what those mean for you as subrecipients. The other highlighted portion in this sentence, as applicable, I think hopefully indicates to you that, yeah, we've got all these contract clauses, but they may not all be applicable at all times. And that is certainly the case. So Appendix 2 lists the contract clauses and then sort of says you have to include these as applicable. So we'll kind of unpack that a little bit more as we go along, but I just want to flag for you those two things and kind of get you thinking about that as we move through this content. So we're going to look at the sections in Appendix 2. There are 12 of them, only 12 contract clauses that you need to include as applicable. But we're going to sort of walk through them, sort of starting with the easy ones, if you will, and then kind of build up into the more complex or complicated contract requirements. All right? So we'll start here. And I've got them listed. So the sort of general requirement is the text paragraph that you see, and then the letter off to the left is the subsection in Appendix 2 where we find the requirement. So subsection A tells us that for contracts above the simplified acquisition threshold, we have to include remedies in our contract when the contractor violates the terms of the contract, right? And so my guess is that your existing contracts probably already have this in place, right? Some sort of default clauses. And so if those aren't in there, you need to make sure if federal funds are in the contract and we're above the simplified acquisition threshold, then you've got those contract clauses in there. Subsection B is talking about termination for cause and termination for convenience. So what this tells us is for all contracts in excess of $10,000, we have to address termination for cause and termination for convenience, including the trigger for the termination and how it will be settled. So termination for convenience, again, I assume that you already have this in your contracts. It's really common in public contracts that we have the ability of the public entity to just terminate the contract kind of for whatever reason it desires or no reason at all. That's why it's called termination for convenience. It's just merely for convenience. There may be additional clauses that spell out termination for cause. So one of the parties has violated a term of the contract, and so we are going to proceed with terminating the contract. And maybe we've already walked through the sort of breach and cure covered by subsection A, but now we have arrived at terminating the contract for cause. So this section in the Appendix 2 is just saying you got to spell all this out in the contract. Subsection C, it requires an equal employment opportunity clause for federally assisted construction contracts. It's required to be sort of verbatim from a different part of our federal regulations. But one note here, President Trump enacted some executive orders that rescinded Executive Order 11246, Equal Employment Opportunity. So I've had some conversations with local government attorneys about whether this clause needs to be modified or whether other sections of their contract templates need to be modified. And so this is just something that you'll want to make sure that your attorney has thought through. All right, still in the realm of easier stuff. We have subsection F, which basically, this is probably not going to apply here in the context of CDBG-DR. This is more for sort of research institutions. But basically, there are certain rights given to the parties to the contract in regards to inventions and sort of other things in the research context. Subsection G, contracts and sub-grants, subcontracts in excess of $150,000, so $150,000 or more, have to contain a provision that requires the agreement to comply with applicable standards, orders, or regulations issued pursuant to the Clean Air Act and the Federal Water Pollution Control Act. So just a contract clause there requiring the grantee or the contractor to comply with those provisions. Subsection K, recipients and subrecipients cannot obligate or expend funds on covered telecommunications equipment or services. So this is a newer addition to the uniform guidance, but basically sort of deals with telecommunications equipment or services provided by certain identified companies. And so you can't use your funds received from the federal government to pay for services or goods from those companies. All right, so that's the easy stuff. We're now going to move into the more complicated stuff. And these aren't all super complicated, but they're a little less straightforward than the ones that we just ran through. And so I've got them listed here on the screen, and we're going to talk about them in this order, starting with debarment and suspension. We'll talk about procurement of recovered materials, Davis-Bacon, and the Copeland Act, Contract Work Hours and Safety Standards Act, domestic preferences. And then the Byrd Anti-Lobbying Amendment, we're going to save that until the final section of this particular session when we talk about conflicts of interest and regulations on public employees' conduct. So let's start with debarment and suspension. So this is subsection H of Appendix 2, and the federal government makes determinations about who can receive its money, right? And in some instances determines that certain companies, for whatever reason, are prohibited from receiving federal funds. Once you, as a subrecipient here, receive federal funds, you have to make sure that you are not giving federal funds through a contract to a vendor that's been suspended or debarred by the federal government, right? The federal government doesn't want their money going to this vendor. So you are sort of part of this process in terms of making sure that that money is not going to the vendor. And so what you're going to do, probably, there's a few different ways to accomplish this, but you're probably going to look up the vendor on sam.gov, right? And so this is a database by the federal government that serves a few different purposes. We'll talk about it also in regards to Davis-Bacon. But on sam.gov, there is an exclusions list, right? So the federal government has provided a list of companies that it has either debarred or suspended from receiving federal funds. And you are going to look for the vendor's name, right? So you've identified your lowest responsible bidder, and you want to make sure that they're not debarred. So you're going to look them up, and hopefully you are not going to find their name. That would be sort of the scenario that you want. If you do find them, right, and you need to determine exactly what's going on with that company, but it could be the case that they are debarred or suspended and you cannot award the contract to them. So that's one way to accomplish compliance here with the debarment or suspension provisions. You can also add a clause or condition to contracts that are covered and require subrecipients to do the same, right? So we're putting into the contract a requirement that says, you know, by entering into this contract, we're, you know, verifying that we're not debarred or suspended. There's an additional way that you can accomplish this, which is obtaining a certification from the contractor about their eligibility status. And so you could do this at various stages in the procurement and contracting process. but it's kind of up to you to decide which of these methods you want to use to ensure that a vendor is not debarred or suspended. You can also take a belt and suspenders approach. Us lawyers love a belt and suspenders combo, because then you know you're in good shape. So you could do more than one of these, but you need to do at least one of them. And if you're doing that SAM.gov search, you want to make sure that you're documenting that for your procurement files. So that is subsection H of Appendix 2, Debarment and Suspension. You also have procurement of recovered materials, subsection J. And so this is sort of, think of this as kind of like sustainability requirements and encouragements. So state governments, an agency that is a political subdivision of the state, and its subcontractors have to comply with Section 6002 of the Solid Waste Disposal Act. And so that applies where we've got a purchase of an item, so we're talking commodities here, exceeding $10,000. And so the procuring entity needs to look at the EPA's list that we find in 40 CFR 247 to figure out if there are recovered materials that they need to use as part of that procurement. So this is really, again, sort of, I think, a purchasing of goods requirement rather than a construction requirement. But it's, you know, it's in Appendix 2, so we got to talk about it. All right. Now we're going to talk about Davis-Bacon. So this is one of the more substantial requirements that we find in the Uniform Guidance, referenced in Appendix 2. And so this is subsection D of Appendix 2. So the Davis-Bacon Act, as a little bit of background, is a federal law that applies to prime construction contracts of $2,000 or more, where the federal government is a party to the contract, or the District of Columbia is a party to the contract. And I don't believe any of you on the call fall into either of those buckets. So the Davis-Bacon Act itself does not apply to you. But then there are sort of Davis-Bacon related acts, which are statutes whereby the prevailing wage requirements of the Davis-Bacon Act are applicable when federal agencies are assisting construction projects through grants, loans, loan guarantees, and insurance. So the Davis-Bacon Act, primarily sort of what we're talking about here is prevailing wages. This is a labor standards requirement. We've got a few other labor standards requirements that we'll talk about, but this is where we find the prevailing wage. And so the Davis-Bacon and related acts requires prime contractors to pay laborers and mechanics prevailing wages. And prevailing wage is sort of wages set by the Department of Labor. They go through sort of a research surveying process based on different labor categories to set prevailing wages for specific geographic areas. That's what the prevailing wage is. And so they make those determinations at the Department of Labor. And then these wages apply when we've got these federally assisted construction projects of $2,000 or more. And so there are obligations on you all in local government to comply with the Davis-Bacon Act. And I'll talk about what those requirements are on some upcoming slides. Another requirement that we find in this Davis-Bacon Act sort of section of Appendix 2 is that prime contractors have to provide weekly certified payrolls for all subcontractors and statements of compliance, which is really sort of a kind of relates to the Copeland Act that we're going to talk about on an upcoming slide. So prime contractors on these federally assisted construction projects have to pay laborers prevailing wages, provide certified payrolls on a weekly basis for all subcontractors, and submit statements of compliance about all of this. We have a few instances where the Davis-Bacon related acts do not apply. So first on the list, demolition as a standalone activity. So If federal funds are being used for demolition, and that's it, then Davis-Bacon does not apply. But more likely what's going to happen with demolition is that there's a project that follows. And so if that demolition is part of a project, other activities and construction, then Davis-Bacon is going to apply. In the context of CDBG, Davis-Bacon does not apply to non-contiguous residential properties. And so this is relevant, I think, for the context of sort of rehab of single-family homes and sort of homeowner programs for rehab. Davis-Bacon and related acts also do not apply to projects with fewer than 8 contiguous residential units if it's funded with CDBG. So if we're talking about 8 contiguous residential units or less, then we do not have to apply Davis-Bacon. But once we get more than 8, we do have to apply Davis-Bacon. And then lastly, force account labor. Force account labor is when a local government is using its own employees for construction. We have a state law exception that provides a little bit more detail on that, but Davis-Bacon is not going to apply there. All right, so now that we have covered the sort of applicability of Davis-Bacon and kind of the basics, let's talk a little bit more about these wage determinations. So where do you find it? What do you need to know? So Davis-Bacon wage determinations are published on sam.gov, which we talked about a few slides ago in reference to suspension and debarment, but also on SAM you can find these wage determinations. And so I've got the hyperlink here, and this is sort of what it looks like when you hop on to sam.gov to find these wage determinations. And so there are 2 types of wage determinations: general wage determinations and project-specific wage determinations. Most of the time you'll be using general wage determinations, right? So the Department of Labor has done the survey and figured out the prevailing wage for different labor categories that are applicable to your project. That information already exists. But it could be that there could be an instance where there's something involved in your project for which a wage determination doesn't exist. And so in that case, you may need a project-specific wage determination. But generally, you're going to be going with that general wage decision. And there are 4 categories of wage decisions: residential, building, highway, and heavy, which is sort of infrastructure related. And so you'll need to find the wage determinations that are specific to your project, because those have to be included in the solicitation documents. And on the next slide, I sort of have laid out for you all of the subrecipient requirements related to Davis-Bacon. But you'll need to sort of look into the wage determination, obtain that wage determination a few different times throughout the procurement process. So subrecipient responsibilities as it relates to Davis-Bacon. First and foremost, you need to identify a labor standards officer. This is an employee who is going to provide Davis-Bacon support, right? They're going to obtain that wage determination. They're going to answer questions about Davis-Bacon. They may be involved with the monitoring that's going to follow once the contract is underway, right? So that's one of the sort of primary responsibilities for you all as a subrecipient. Subrecipients should also establish a construction contract management system that enables appropriate involvement by the LSO, right? So you could identify an LSO, but if they're not getting notification of projects that may need a wage determination attached to them, then that's not going to be helpful, right? So you need to have a sort of process in place, kind of a management system that allows the LSO to be involved at the various points when they need to be providing input on a Davis-Bacon project. I mentioned this already, 3rd bullet, subrecipients have to include the wage determination in solicitation documents, right? So you're going to get that general wage determination, attach it to your solicitation, so that bidders are aware of the requirements around wages. You'll also have to include federal labor standards contract clauses in contracts covered by Davis-Bacon. And I've got a little bit more information about that contract clause on the next slide. So once you've obtained the wage determination, you include it with your solicitation. You also have to check it 10 days before bid opening. And the reason for that is that wage determinations can change. And so you want to make sure you're still sort of acting under the most recent wage determination. So you've got to check for any modifications 10 days before bid opening. Then once you're under contract, right, you have to make sure that the prime contractor is in fact paying people according to their labor classifications and the associated prevailing wages. So there are kind of significant monitoring requirements that follow along with Davis-Bacon. So this is going to be interviews of people on site, making sure that they're getting paid appropriately, checking those certified payrolls and whatnot. So there's a lot of work that goes along with Davis-Bacon, and this is a requirement that applies for CDBG-DR. So here I have on the slide, as you can see, a picture of a toolbox. The purpose of this presentation today is to sort of get you thinking about compliance, right? But I could probably spend a whole day, if not longer, talking about Davis-Bacon. So there are a lot of resources available for you after we leave today. And this slide includes some of those resources. You can consider this sort of tools in your toolbox. So the HUD Exchange has a training if you want to learn a little bit more about Davis-Bacon. I mentioned earlier that your contracts have to include those federal labor standards provisions. There is a form that HUD has for that. It's linked here in the second question. There are also other forms that HUD has, such as a monitoring review guide for agency on-sites. So when HUD comes to make sure that you're doing Davis-Bacon, you can understand what it is that they'll be looking for. It's a really helpful resource to understand what you need to consider for compliance. And then Haywood County has adopted a Davis-Bacon and related acts policy just a couple of months ago. And so their policy covers a lot of what I've talked about here in the past couple of slides. And so you can see an example of that policy linked here. So that's Davis-Bacon. I mentioned that Davis-Bacon is a labor standards requirement. We have a couple of other labor standards requirements that I'm going to talk about next. One of them is the Copeland Act, sometimes referred to as the Copeland Anti-Kickback Act. And the language, the requirements here are sort of grouped with the Davis-Bacon language under Appendix 2. So this is also in subsection D. And so this applies to contractors and subcontractors that perform work on contracts for construction, financed in part with money from the federal government. So what this prohibits is a contractor or subcontractor can't force or induce an employee to give up or kick back any portion of their wages that were rightfully earned. So that's the anti-kickback provision. And then the Copeland Act and implementing regulations also requires contractors and subcontractors performing uncovered contracts to pay their employees weekly and provide sort of a weekly payroll statement for the previous week. So folks have to be paid weekly and provided a statement for the preceding week. So that is the Copeland Act. Then also relatedly, we have the Contract Work Hours and Safety Standards Act. So this is subsection E of Appendix 2, and this applies to federally assisted construction contracts over $100,000 subject to the Davis-Bacon related acts labor standards. So if Davis-Bacon applies, this one also applies if it's over $100,000. There's a couple exceptions here where it doesn't apply. I'm not going to get into that. But essentially what this is requiring is that contractors and subcontractors have to base their employees' work weeks on a 40-hour work week, and any time worked over that has to be paid at 1.5 times the basic rate. So that is the Contract Work Hours and Safety Standards Act. All right, moving on from labor standards, now let's talk about domestic preferences. So we find language in subsection L of Appendix 2, right, so our contract clauses, that encourages the use of domestically produced materials. So you've probably heard of BABA. I mentioned it earlier, but you're probably familiar with it in other contexts. The Build America, Buy America Act, which was part of the Infrastructure Investment and Jobs Act of 2021. There are several different ways in which domestic preferences sort of show up in federal law. And so I have them listed here. I'll sort of talk about them in a little bit more detail, but the one that I'm going to focus on is the one you see in the middle that comes from the Uniform Guidance. So federal agencies are subject to what's known as the Buy American Act of 1933. We're not going to talk about that in detail. You don't need to know it. We also have sort of what I've mentioned already, BABA, the Build America, Buy America Act, as part of the Infrastructure and Investment Jobs Act. And so I've mentioned this already. I'll mention it again. BABA, that sort of hard preference, meaning it is essentially a requirement, does not apply to CDBG-DR funding, right? But depending on the mix of federal funds, it could be a requirement, right? So, for example, if you're doing a project and you've got CDBG-DR and FEMA funds involved, BABA also does not apply to FEMA Public Assistance and FEMA Hazard Mitigation Grant Program, but there are about 24 other FEMA programs to which BABA does apply. So you really need to know what you're dealing with in terms of your funding mix. But for CDBG-DR purposes, BABA does not apply. So what we're left with is the soft preference that we find under the Uniform Guidance. And it's called a soft preference because it's really sort of language that encourages the use of domestically produced materials as opposed to sort of the hard requirements of BABA. So it's a should, it's an encouragement. One of the only things that you need to know about that contract clause that is an actual requirement is that you have to include the contract clause in your contracts, right? So you've got to include this contract clause that we find in 2 CFR 200.322 in your contracts, all right? So that's what you need to know about domestic preferences. We are now going to move along and get into CDBG specific requirements. All right, so this is URA Section 3 and Section 104D that we're going to be talking about. Before we get there, I want to talk about some procurement alternative requirements that we find in the Uniform Notice. So remember back in the earlier session, we sort of looked at the regulatory landscape and we had sort of the overlapping, the Venn diagram of all the different sources of laws and regulation here in regards to procurement. And so one of those was the Uniform Notice. And so the Uniform Notice says that HUD has established what it calls additional alternative requirements for all procurement actions. But I really think of these as contracting requirements rather than procurement requirements. And so these are specifically listed below. So the procuring entity, which would be you all in a procurement action, is required to clearly state the period of performance or date of completion in all contracts. Basically, you've got to have an end to the term of the contract, right? The second requirement says the procuring entity must incorporate performance requirements and liquidated damages as applicable into each procured contract. And this sort of as applicable is because liquidated damages are really sort of a tool used in construction contracts, wouldn't necessarily be appropriate, as this uniform notice points out, in a consulting contract. But at a minimum, you have to include performance requirements, right? We have to know sort of the benchmarks to which we are holding our contractors in order to understand whether they've complied and to be able to effectively manage that contract. So you have to incorporate performance requirements into your contracts. And then the last thing that they added in these alternative requirements, you can see here on the screen, it says the procuring entity may contract for administrative support, but may not delegate or contract to any other party any inherently governmental responsibilities related to the oversight of the grant, including policy development, fair housing and civil rights, compliance, and financial management. So there have been some FAQs following up on this particular provision, because I think what folks were concerned about with this language is, does that mean we can't contract for these sort of things that are listed off, like policy development? And what HUD replied in response to that question is, no, you can still contract for those things like policy development, but you have to monitor those contractors and make sure that you are still taking responsibility for the decisions that are being made, right? So you can't just have a total handoff on these responsibilities. You can contract for assistance on these responsibilities, but not a total handoff, is the gist of that. So those are just a couple of uniform notice contracting requirements that I wanted to highlight for you before we got into all the various CDBG specific cross-cutting requirements. All right, so CDBG funds require more. We're going to talk about the Uniform Relocation Act, Section 104D, Section 3, and we're going to touch on fair housing and non-discrimination requirements. So we'll start with the Uniform Relocation Act. And so if you're not familiar, the Uniform Relocation Act is a federal law that governs the acquisition of property in a federally assisted construction project and provides protection and assistance to displaced people due to a federally assisted construction project. It also applies to federal projects, but obviously our scope here is federally assisted construction projects. And so an important point about the applicability of the URA is that the URA applies to any project that involves property acquisition, rehabilitation, or demolition if federal funds are to be used at any stage of the project. So it doesn't have to be the case that federal funds are being used for one of those three activities or more than one of those three activities. If a project involves demolition and then that project will also involve federal funds down the road, the URA applies. All right. What that means is you really have to plan and think through how these projects are going to happen to know whether you need to follow the URA or not. And the URA has kind of two types of requirements, right? There's acquisition and relocation requirements. And so when we're talking about acquisition, we're talking about, sort of taking private property. And there's a whole body of law around sort of takings, condemnation, eminent domain. But there are two ways that acquisition can occur under the URA. It can be involuntary, which could end up in the exercise of eminent domain, or voluntary, which is not going to result in eminent domain. And procedurally, an involuntary acquisition is sort of the most rigorous process. It's sort of subject to the most requirements under the URA, whereas a voluntary acquisition has lesser requirements under the URA. So acquisition is one type of activity covered by the URA. We also have these relocation requirements that arise when someone, an individual or a business is going to be displaced from property due to a project. And that displacement could be temporary or it could be permanent. And depending on sort of the nature of the displacement, there are additional and different requirements that apply. So that's kind of the gist of the URA, right? We're providing protection for people's property, for people whose property is being acquired, and then people who are being displaced by these federally assisted projects. I've got a note here, the URA is actually not specific just to CDBG-DR, like the other two requirements that we're going to talk about. The Department of Transportation is the administering federal agency for the URA, but HUD has a few of its own requirements in implementing the URA. One of them is like specific to notice, and I'll touch on that in just a moment. So if the URA applies, one of the big things that you need to know, besides sort of planning your process, is that there are notice requirements. And these notice requirements, I've got them listed here. I'll talk about them in a little bit more detail. But these notices are really critical under the URA, right? Because they're giving notice to a property owner that their property may be acquired, or a tenant that they may be displaced due to this project. And then if one of those things actually does happen, there are additional notices that need to be given. So the first notice that we have is the general information notice. And like I alluded to earlier, this is providing notice to people that they may be displaced. So as a project's taking shape, it could be the case that, you know, the exact nature of the sort of impositions on the property aren't known, and so we're giving them notice that they may be displaced. But once it becomes clear that a person is going to be displaced, then we have to give them additional notices, right? So we've got the notice of relocation eligibility, the second one listed here, and this informs people that they are going to be displaced by a project, and then that triggers their eligibility for relocation benefits under the URA. So if a person is going to be displaced, then they may be eligible for relocation benefits, including moving expenses and other assistance. The last notice that I have listed here is a 90-day notice. And so what this in essence says is that when we have someone who's going to be displaced, we have to give them 90 days notice of the date by which they're required to move. It's a little bit more complicated than that, just depending on sort of the nature of the circumstances and what other notices they may have been given and whether there's comparable housing available. I'm not going to get into all of those details. The big takeaway that I want you to understand here is that there are different notices that you have to give along the way depending on how properties and occupants of the property are being treated. Then, as I've already mentioned, right, if an occupant of the property is going to be displaced, then they are eligible for those relocation benefits, such as actual and reasonable moving expenses and reestablishment expenses, or a payment in lieu of those expenses. Again, that's a whole big section that we find under the Uniform Relocation Act in terms of calculating what those benefits are, how we come up with those payments. A whole nother section of the URA on how we pay people just compensation when we are acquiring their property. A lot of details here in the Uniform Relocation Act, but this is a really important procedural element when we are going to be displacing individuals or acquiring property. So if you want to know more, the HUD Exchange has a page all about URA the HUD way. Is actually really helpful. They've got short informational videos and written resources like flow charts and kind of one-page fact sheets. I just published a blog post about the Uniform Relocation Act, sort of the basics and those triggers that I mentioned earlier in terms of the notices. So you can find that blog post on the link there. And then Another sort of element related to relocation is something called a Residential Anti-Displacement and Relocation Assistance Plan, a RARAP. And so this is something that the state is responsible for developing. And so that's something that I think is forthcoming in terms of a policy that we'll see from Commerce. And subrecipients, you all in local government, can adopt the grantee's RARAP, or you can adopt your own. So you'll need to keep an eye out for that. If you want to know sort of what monitoring for URA compliance looks like, there is a file checklist developed by the state of Montana that might be a helpful go-by to get you thinking about how you need to sort of document everything along the way. So that's the URA. Just really high level there. Again, it's something we could spend days talking about. But the point of my conversation with you here is to just get this on your radar, let you know that this is something you need to be thinking about and planning for. Next up is Section 104D. So this is a CDBG specific requirement, and this is another sort of relocation requirement. So the URA, like I mentioned, is not CDBG specific, but this one is. And so this applies when CDBG funding is used in connection with the demolition of lower income residential structures, or the conversion of those lower income dwelling units to something other than a lower income dwelling unit. So a little bit different in terms of applicability. Lower income dwelling unit, of course, a defined term under Section 104D. There are three basic requirements of Section 104D. That RARAP is required. There's also provisions on a one-for-one replacement and a special sort of relocation assistance that's available to these residents. And so, again, that RARAP is a document that provides guidance on sort of the relocation requirements and explains procedures in compliance with the URA and Section 104D. And so we'll be on the lookout for that, and you all can figure out whether you want to adopt the state's RARAP or use your own. The one-for-one replacement essentially says where a lower income dwelling unit is demolished or converted, it has to be replaced with another affordable unit. It's got that replacement unit has to be in the same jurisdiction and meet the same affordability and occupancy standards. And then special relocation assistance. So this is somewhat similar to the URA. So these displaced lower income households can receive relocation benefits. So I'll note here that typically displaced lower income persons under Section 104D are generally entitled to choose either relocation assistance under 104D or relocation assistance under the URA. The sort of calculations and availability of sort of financial resources there is a little bit different. But the universal notice waives Section 104D requirements to align the relocation assistance in terms of financial calculations with the URA. So there's not a distinction on the calculation for Section 104D here as opposed to the URA. The eligibility under Section 104D remains the same. And one of the big things that I'll note here is that the URA prohibits aliens who are not lawfully present in the United States from receiving relocation assistance. Section 104D does not have that same prohibition. And so that is, I think, a big difference in eligibility as between the two. Additionally, under Section 104D, homeowners and non-residential entities are not eligible for Section 104D relocation assistance regardless of their income. It's kind of another distinction with the URA. So that's the sort of basics of the URA. Again, we've got resources to provide you with some more information. You can find those in the Section 104D summary linked off to the side under the toolbox. The last CDBG specific requirement that I want to talk about is Section 3. Section 3 is a little bit complicated, but I'll start by talking about the purpose of Section 3. So the purpose of Section 3 is where we have HUD assistance funding a project, right? We want to ensure that any economic opportunities and employment opportunities that are created by that HUD-funded project are directed to low and very low income people and businesses that provide economic opportunities to those people, and that may be owned by those people, businesses that may be owned by those people. So it's really sort of recognizing that when federal funding is being used for a project, there are opportunities there, and we want to make sure that those opportunities are being made available to these lower income individuals. And so Section 3 applies to projects or activities involving housing or other construction when the recipient has contracted for services and the CDBG assistance in the project exceeds $200,000. So probably a lot of the projects that you all might be contemplating, I'm guessing, exceed $200,000. And so Section 3, you need to take a look at and figure out whether it applies. Section 3 does not apply to projects that do not involve rehab and new construction, and it does not apply to materials-only contracts. So if we're not doing rehab or new construction, then we don't necessarily need to worry about Section 3. The implementing regulations for Section 3 are found at 24 CFR Part 75. And here's a little bit more sort of detail about what is required by Section 3. And so you'll see a couple of terms here: Section 3 workers, Section 3 business concerns. These are defined terms under Section 3 of the Act. And so I'm not going to get into all the details here in terms of definitions, but you can take a look, of course, at those regulations. So direct recipients of HUD financial assistance and their contractors and subcontractors are required to provide, to the greatest extent feasible, contracts, employment, and training, and other economic opportunities to low and very low income persons in the local jurisdiction, who are referred to as Section 3 workers, and to businesses that employ or are majority owned by those persons, referred to as Section 3 business concerns. So you'll notice here sort of the first couple of words of this say direct recipients of HUD financial assistance. So obviously Commerce, as the grantee, is sort of responsible for ensuring compliance with Section 3, but the obligations of Section 3 flow down to subrecipients, and so that's why we're talking about this. One of the primary requirements in terms of compliance with Section 3 focuses on benchmarks. So HUD has established benchmarks to indicate compliance with Section 3. So what we're talking about here, again, is employing Section 3 workers, training Section 3 workers, contracting with Section 3 workers. And so these benchmarks focus on sort of the employment and look at whether 25% of the total labor hours worked on a Section 3 project are done by Section 3 workers, and then at least 5% of those total labor hours performed by targeted Section 3 workers. And so these benchmarks, again, adopted by HUD, these are the benchmarks that were adopted in 2020. HUD is obligated to review and update, if necessary, these benchmarks every 3 years. They took a look at these in 2023 and decided to keep them as is based on their 2020 calculations. And so these are the ones that are in place, but of course, every 3 years, these could change in 2026. These benchmarks relate to what is known as the safe harbor for compliance under Section 3. And what this safe harbor means is that if you've met these benchmarks and you have followed the required prioritization under 24 CFR 75.19, so sort of taken certain actions, then you will have been deemed to be in compliance. It's sort of, it's sort of like these two things together are representing that you have complied with Section 3, right? And HUD doesn't need to take a closer look at what you're doing. But if you have not met the safe harbor benchmarks, then you as a subrecipient are going to have to show best efforts to comply with Section 3. So doing things to encourage participation by Section 3 workers, targeted Section 3 workers, and Section 3 business concerns. There are additional subrecipient requirements, which I have listed here, in terms of including a Section 3 requirement in contracts, monitoring for those labor compliance benchmarks, outreach and documentation, and record keeping. HUD has FAQs on all sorts of topics, including Section 3, and I found that this FAQ was particularly useful in understanding kind of the expectations that HUB has for subrecipients. So you can click on that link, kind of see the full kind of list of what HUD expects, but I think that what stood out to me was sort of the introductory language in response to this question, which was that recipient agencies are expected to take an active role ensuring Section 3 compliance, right? So there's more to this than just sort of checking boxes, right? This is a requirement that is going to require a lot of your agency, and HUD expects you to have an active role in the process. Here are additional resources that you can find. HUD has a Section 3 in Action webpage. They also have final rule videos intended for internal partners, like some of you on the call, procurement staff and attorneys, and external partners, like contractors. You can also see if your Section 3 question has already been asked. So HUD has a couple of FAQ resources. They have a document that's sort of a static document updated earlier this year, and then they have a web page where they add new questions. Based on what I could tell, these were sort of two different documents. They're not duplicative of one another, but you can take a look and see if your Section 3 question has already been asked. And then you may consider adopting a Section 3 plan. You are not required to have one, but HUD does advise that this is a best practice. This is obviously a pretty complex regulation, and so if you want to make sure that people are doing what they're supposed to, both within your organization and as contractors with your organization, the easiest way to do that is to communicate it in writing through a policy. All right, last but not least, fair housing and non-discrimination obligations. So we find language and regulations that say the grantee must use its CDBG-DR funds in a manner that complies with its fair housing and non-discrimination obligations, which include all of these different statutes. And so the grantee, right, this is referencing the grantee, this is language from the universal notice, and then sort of the updated universal notice following the March memorandum. And so, yes, the grantee is responsible for compliance with these, but you all as local governments also have to comply with these various federal laws. And so I'm just flagging this for you as some additional regulatory context, but we're not going to get into the details of all of this here. All right. That's what I wanted to talk about in terms of CDBG specific requirements. The last thing that I want to leave you with is a conversation on conflicts of interest. And so conflicts of interest crop up in a lot of different ways, and especially when we're talking about procurement, there's a lot of money, at stake, and so there are a lot of opportunities for exploitation of the procurement process. And so Rebecca talked about earlier kind of internal controls, having mechanisms in place to sort of manage these processes, not just procurement, right, but other finance processes. But conflicts of interest is a really important aspect related to procurement and contracting. And so we're going to talk about the Uniform Guidance Regulations and CDBG regulations on conflicts of interest. And then I'm also going to touch on something that I've sort of been hinting at all day, which is this this conflict of interest related to contractors who draft specifications being prohibited from competing for the work. So those are kind of the big things that we're going to talk about in the upcoming slides, and then we will be done. All right, so we find a conflicts of interest provision in the Uniform Guidance in 2 CFR 200.318. And what it says, you already know this because I've repeated it several times, is that you have to have written standards of conduct related to conflicts of interest, governing the actions of employees engaged in making or administering contracts. And so the Uniform Guidance spells out real and apparent conflicts of interest. Well, it spells out real conflicts of interest. It actually doesn't define apparent conflicts of interest. But what it says is an employee, officer, or agent with a real or apparent conflict of interest is prohibited from participating in the making or administering of a contract supported by federal funds. So if an employee, officer, or agent has a conflict of interest, real or apparent, related to a contract supported by federal funds, they can't participate in the making or administering of that contract, right? And you can imagine why, right? We don't want people who have interests in contracts influencing the contracting process. And so, I said this already, apparent conflict of interest is not defined in the Uniform Guidance, but federal agencies sort of regularly tell us that an apparent conflict of interest exists when a reasonable person would have reason to doubt the objectivity of the decision maker, right? So basically, if it looks fishy, we've probably got an apparent conflict of interest on our hands. The Uniform Guidance does define a real conflict of interest. And so it says a real conflict of interest exists when any employee, officer, agent, board members, any member of their family, business partners, or an organization that employs any of these people has a financial interest in, a tangible personal benefit from, or other interest in a firm considered for a contract. That is a lot of different relationships at play, right? So we're not just talking about employees or officers, which is sort of the limited universe that we find under state law. We're talking about employees, officers, agents, people related to those folks, business partners, an organization that employs any of those people, right? If any of those individuals or entities has a financial interest in, tangible personal benefit from, or other interest in a firm considered for a contract, then we have a real conflict of interest relating to that employee, officer, or agent involved in making or administering the contract, right? So this came up with ARPA, and one of our former colleagues here at the School of Government, Connor Cruz, drafted a conflicts of interest policy. So I have it linked here at the bottom of this slide, and it's a good starting point for kind of mapping out, identifying conflicts of interest and how they're to be handled in your organization in a way that complies with both state law and federal rules. So take a look at that policy, see if your policy needs updating, and you can use this as sort of a starting point. We also know that CDBG has its own program administrative requirements related to conflicts of interest. So we find these in 24 CFR 570, 489 G and H. And so they're kind of, the way I read this section, there are sort of two separate conflict of interest provisions depending on the nature of the transaction. So there's type 1, which really relates to procurement transactions, and then there's type 2, which relates to anything not covered in type 1, so things like the disposition and acquisition of real property and the provision of assistance with CDBG funds to sort of beneficiaries. So type 1 and type 2 we find in subsection G and H. And so this type 1, when we're talking about procurement, what HUD tells us is that we need to look at the employees engaged in the administration of contracts or the award of contracts, and the state, so Commerce, can direct subrecipients to follow the uniform guidance, or the state has the ability to kind of enact its own conflict of interest standards here, so long as it sort of complies with kind of minimum requirements set out in subsection G. So my guess is that we'll probably end up with kind of a uniform guidance, procurement, conflict of interest type regulation, which means just think about the slide that we just talked about. If we're talking about this,
involved in this book report before I answer any of those questions.
What'd you say, Rebecca? Okay. Now I'm going to talk about type 2, these type 2 transactions. So again, this is when we're talking about something other than procurement, something other than this sort of type 1 transaction. So covered people, we sort of need to look first at like who's covered by this conflict of interest provision. So covered people are any employee, agent, consultant, officer, elected official, appointed official of the state or local government, subrecipients receiving CDBG funds. So employee, agent, consultant, officer, elected official, appointed official. Those folks, those are our covered people, right? So a covered person who exercises or has exercised any functions or responsibilities with respect to CDBG activities and is in a position to participate in a decision-making process or gains inside information, or if there's the individuals that they have family or business ties to, those folks cannot benefit from a CDBG assisted activity for themselves. All right, so that's a lot there, right? So we have to look at these covered people and then look at their involvement with kind of the administration of CDBG programs, the decision making that they're involved with in those programs, or sort of access to insider information, kind of information that's not yet public. And so if a covered person sort of falls into any of those categories, they cannot benefit from CDBG assisted activities, and their family, individuals with whom they have business ties, cannot benefit from those activities. There's a period of applicability here. It applies to kind of the person while they are working with the unit that's covered, and 1 year after their departure from that organization. So that's also, to me, sort of a big consideration in terms of tracking these conflicts of interest. There are exceptions. The state can grant an exception to a local government if there's been a public disclosure of the conflict of interest and the local government's attorney provides an opinion saying that the interest would not violate state or local law. So there's a little bit of an out there, but you may not want to find yourself in that situation. A couple of other regulations on conduct, the Byrd Anti-Lobbying Amendment. So we find reference to this in Appendix 2. I mentioned that earlier, but I said I was going to save it for this section. And so the Byrd Anti-Lobbying Amendment prohibits using federal funds to lobby Congress or a federal agency to award or renew a federal contract, grant, loan, cooperative agreement. Basically, you can't use federal funds for lobbying, right? For lobbying the federal government. And so recipients of federal funds have to include contract provisions where we've got include contract provisions and then certifications where contractors will be bidding work of $100,000 or more. There's also a certification that folks will have to fill out, sort of verifying that they haven't used federal funds in violation of the amendment, and disclose lobbying activities related to a contract, grant, or loan. Then we have the Hatch Act. The Hatch Act restricts the political activity of individuals principally employed by the state, by states, District of Columbia, or local agencies, and work in connection with programs financed in whole or part by federal loans or grants. So the Hatch Act prevents folks from kind of running for office in a partisan election if their salary is entirely federally funded. And my guess is that's probably not going to be the case for most folks. But also prohibits using official authority to influence or affect the results of elections or nominations for office, or directly or indirectly coercing employees or officers to contribute anything of value to a party, committee, organization, agency, or person for political purposes. So don't make your employees donate to the sheriff's campaign. All right, a couple of other prohibitions that I want to touch on. Other prohibited conflicts under federal regulations and state law. I'm going to start with state law, then I'm going to move on to federal regulations. So we have a few prohibitions on design professionals. And remember that we talked about design professionals, architectural and engineering services earlier. So when we were talking about A&E, those architects and engineers cannot have a financial interest in the materials or equipment that they are specifying, right? Because that would just be a conflict of interest. Additionally, a manufacturer cannot draw up specifications and then the architect or engineer sort of hands them off as their own, right? And all of this is sort of relates to the fair and open competition principles that we have been talking about. Shifting over to the uniform guidance, there's a prohibition on specifying brand name products. What the uniform guidance wants you to do is to spell out performance requirements. And again, this is really for design professionals who are going to be drawing those specifications. We want to make sure that they are focused on performance rather than brand names, because brand names are restrictive of competition. There's additional language that we find in the uniform guidance that allows a little bit of flexibility there, but I think as a starting point, don't use brand names. But the big one that I want to focus on is that contractors who develop or draft specifications, requirements, statements of work, or other invitations for bid or requests for proposals cannot compete on those procurements. I mentioned earlier that we don't have a similar prohibition in state law. This is something unique to the uniform guidance. And so my guess is that some of you may be at the design stage, right? You may be hiring engineers to sort of start thinking through projects, designing projects for eventual application to receive CDBG-DR funding. And so I just want you to be aware that if you have an engineer who may be involved in drafting specifications, that engineer cannot then turn around and bid on the work once you're ready to procure for the project. And so this is, I think, and sometimes overlooked because, again, we don't have an equivalent in state law, but this is a really important conflict of interest provision that I want to mention, particularly for you all as a matter of timing, kind of where you might be at in your planning processes. All right, so that's it on conflicts of interest. I'm going to leave you with a few final notes, kind of putting this all together, the procurement piece, the sort of puzzles that we talked about earlier today, and then these cross-cutting federal requirements, right? This is a lot of information that I've thrown at you, that Rebecca's thrown at you today. The thing that I want you to remember is you don't need to know it all now, right? We have been providing you with information to get you thinking, kind of get these things on your radar so you can really sort of holistically understand what a project is going to require in terms of resources and planning, right? Davis-Bacon, Section 3, that's going to require a lot more in terms of your resources at the local level. So really just want you to be thinking about those things, but I also want you to remember that we're here for you as the partner agencies to support you. And so I want to leave you with a few final thoughts on kind of getting ready, considering how you might get prepared for these federal procurements. So you want to make sure that you have an updated procurement policy. You want to make sure that you have an updated conflict of interest policy. As I mentioned, and as you can see here on the screen, we have samples available for you. You may want to self-certify your unit's micro-purchase threshold. We talked about that in the earlier session today. That's going to make things a little easier for you on the procurement front when we're talking lower dollar amounts. You may want to authorize electronic advertising for formal purchases in construction or repair, which is going to save you some effort in advertising. You can advertise on your website, you can advertise on the electronic vendor portal, lots of other places that you could advertise in lieu of newspaper advertising. You want to develop contract clauses to comply with federal agency guidance and Appendix 2 of 2 CFR 200. So we just spent this latter session talking about all of those or all those contract provisions and the cross-cutting federal requirements. So you want to make sure that you have contract clauses that are appropriate for the project. Typically what I see is that local governments will come up with sort of an addendum that includes all of the contract clauses that could possibly be applicable, and they just sort of tack that on to their standard templates. And that certainly is one way to go about it. That way you make sure that everything is included. Although I'll let you know that sometimes contractors will push back because they'll say, I'm not doing construction, why do you have Davis-Bacon in here, right? So you might have to sort of contend with that. But I think it's a really effective approach if you just want to have a sort of tack on. And so I think here at the School of Government, we'll probably be working on some of those contract clauses. We did it for FEMA PA in the fall of last year. And so we want to see if there's a way for us to provide that support here. So be on the lookout for that. Another thing that I want to mention is we're here for you as the partner agencies, but you also can hire folks to help you, right? So there are lots of consultants available who do some of this CDBG compliance, federal contracting compliance, who do construction management, help you manage your construction projects from beginning to end, right? And on that latter piece, construction management, I wrote a blog post on construction project advisory services, kind of what you need to think about in terms of capacity, what you might hire a project advisor to do, and a kind of checklist for all of that. So you can access that in the blog post link there. You want to adopt policies to direct employees on procedures for CDBG-DR compliance, right? Rebecca talked about some policies earlier. I referenced some policies, right? So Haywood County has a Davis-Bacon related acts policy. You may consider adopting a Section 3 policy, which is a recommended best practice by HUD. So policies certainly are the way to go. Requires more work up front, but hopefully will save you some headaches down the road. Work with your attorneys. I cannot say that enough. Not saying it just because I am an attorney. But your attorneys, they understand this stuff too. They're good at looking through regulations, making sure that you've kind of crossed those T's, dotted those I's. They can help you sort of think through these things from a contractual perspective. And then lastly, be on the lookout for forthcoming resources, right? Commerce is still sort of working diligently to get its sort of programming up and running. And other state agencies and offices are sort of helping with these efforts, and the partners are also working together to provide your agencies with guidance and support.